Hello, today is Wednesday, March 20th, 2019. I'm Joe Schmidt with TC2, and this is Staying Connected. On today's podcast, I'm joined by Deb Boehling, a partner at LB3, and Pat Gilpatrick, a fellow project director at TC2. And we're going to look at how to align your legal resources with your technology projects. Okay, Pat, why don't you kick us off?
Thanks, Joe. Telecom projects, as you know, cut across a lot of facets of the enterprise. They involve timelines, budgets, resources, and operational impacts. And because of that, they involve a wide number of stakeholders: IT people, security people, finance people, vendor management, procurement, and certainly, last but not least, legal resources. So what we wanted to talk about today is our experience with legal resources involved in a telecom deal. What role do they play? How they can be used most effectively? And there are basically two kinds of deals that we are involved in. Most of our clients are involved in. One is a competitive RFP with potentially new suppliers or services versus incumbent negotiations, which are usually contract extensions or renewals. When RFPs are involved, there's typically more legal involvement because there may be a new master service agreement that's needed, just generally a broader touch from legal resources. If you have an extension, it may involve less support because often it may represent just buying more of the same service or the same places. But even when that happens, suppliers tend to touch their commercial and legal terms and conditions whenever they have a chance. They love to introduce these changes. So there's hardly any deals we do where legal's not involved in some capacity.
Okay, Deb, you're the lawyer amongst us, so why don't you explain what a legal resource is and what the role is of the legal resource?
Sure, Joe. A legal resource is someone like me. It's legal counsel that knows laws affecting the contract and the parties' obligations, laws well beyond the governing law of the contract. We use this knowledge to assist with the transaction. We analyze and advise on contractual risk allocation between your company and the vendor, and assist in properly documenting the business agreements reached, fleshing out the high-level agreement into the details necessary to align with your company's expectations of how things will really work. Your company can use in-house counsel or it can hire outside counsel. It's rare, though, for outside counsel to work without consultation with in-house counsel. There are advantages and disadvantages to each approach. In-house counsel typically has numerous responsibilities and priorities pulling them in different directions, even when they're designated as telecom or technology sourcing counsel. Outside counsel, instead, can prioritize you and your project, and we know technology and the ways technology is used by enterprise customers. In-house counsel is familiar with what your company requests as an opening position and what your company will accept as a bottom line, but they're not as familiar in understanding market-leading terms and which vendors are more likely to agree to them.
Now, I've heard legal referred to as the Office of Sales Avoidance, with the underlying reference to not bring legal resources into the mix too early in a project. So, Deb, when should a legal resource be brought in?
Okay, Joe, I'm going to give you a pass on the lawyer dig because I think one of my fellow partners came up with that term. A common approach, particularly for understaffed, overworked enterprise customers, is to bring in legal after the contracts are drafted and provided by the winning supplier or suppliers. You have other projects in your funnel and may believe that pricing and major commercial terms constitute 90 to 95% of the deal. Bringing in legal after you believe the pricing and commercial terms are done risks delays in the signature of the contract, in cost savings, in implementation if new services or vendors are involved. Why? Your legal is likely also overworked with competing projects and hasn't planned for or prioritized the reviews of your contract. Your legal hasn't been part of the negotiations and is often viewed as an interloper by all involved. It's worse when the vendor legal has been involved throughout the negotiations, which often happens, and your legal has not been involved. It also means deal breaker terms are discovered after awarding the business to the vendor. Your legal is able to identify business and reputational risks that may not have been included in previous negotiations. These include your company's indemnification obligations, regulatory obligations if your company's a regulated entity, confidentiality and privacy, information security, limitations of liability, disclaimers of liability, all of those things that folks think of as legal but have business and operational impacts.
And yeah, let me add another thing to that as well, Joe. We also find often if the vendor's already aware that they've won the business and then the contracts come in, there's often a disconnect between the sales teams and their legal folks as well. So you would expect the contracts to come in with all of those carefully negotiated terms that you have worked so hard to obtain. But often that's not the case because the folks who create those drafts have not been as connected to the sales offers as they should have been. So there's a lot of things conspicuously absent on those documents, and there's a lot of backsliding when those are brought to the table, and we ask, where are they? And the legal folks are unaware. So it creates another set of delays with looking at those kind of contracts after the fact when there's little leverage left in the deal.
And I just completed a deal last week where the last issue was the definition of user. It's one of those miscellaneous legal provisions that the business kind of just glances over or glazes over, I should say. It usually puts you to sleep. It was a definition. But the vendor defined the user as anyone that uses the service purchased by the enterprise. That appeared to be innocuous to the in-house legal counsel who wasn't familiar with the vendor's risks aversion. But that definition determines the breadth of the enterprise's potential liability. Upon closer examination of the definition, fraudulent users and hackers actually use the service your enterprise buys, and this would have made the enterprise responsible not just for charges, but for any bad acts of persons over which it has no control, and those who showed their irreverence to the law by hacking into your system.
So, Deb, sometimes clients want to include their contracts in the RFP, and I always tell them that's a bad idea, but what do you think?
I agree. Bringing them in too early can be a problem. It makes vendor legal become involved earlier than you would like, at the very beginning of the project. This may just delay responses to or movement on your RFP requirements, as vendor legal is there to address risks, real or imagined, while vendor sales is anxious to win the business. Without vendor legal involved, sales' RFP responses are enticing, and you can use these when negotiations get tough. Moreover, larger vendors strongly resist working off customers' paper. The response you get now that the vendor legal is involved will likely be a copy of their standard form contract from the non-incumbents and references to the existing contract for incumbents. This disadvantages non-incumbents as their standard contracts are not customer-friendly, and they may not be willing to have or to be willing to have assigned their vendor legal resources to thoroughly respond to the customer-requested MSA. Incumbents, however, simply point to existing terms as a fast way to get the deal done, believing you will take risks accepted at the last renewal. If, however, the non-incumbent negotiating team has the vendor legal take a fresh look at your concerns and your requirements, they may be more willing to address them to get the business than even your existing vendor was last go round. They don't have a contract to fall back on for issues like data privacy and information security, areas where many customers now want more from their incumbents. And incumbents resist changes, and as Pat mentioned, they might want to backslide on what's even in their current contract.
Yeah, so we've talked, frankly, about two extremes. One where things are done, like Deb just mentioned, if the RFP includes too much legal information, it can involve too much negotiation and too much disparity in responses up front. The other is where you wait too late and you bring in legal resources after awards have been made and things are too far along and result in delays or other issues. What we found is more of an optimal middle ground is to select what the client thinks are the most important commercial and legal terms. You do a cherry-picking type of approach for the very important things that need to be addressed. You put those selected terms into the T's and C's of an RFP. You use the responses to those to narrow the field and move toward your finalists. And then prior to awards, you can engage legal to review drafts, preferably for more than one supplier, and preferably also for the service attachments that come along with it to identify gaps or risks at that point in time that can be addressed while you still have some leverage over the decision-making. In any case, it's important to communicate early and often with whoever the legal resources are to minimize delays due to resource limitations and extended negotiations due to unrecognized or unidentified risks.
Okay, thank you, Pat, and thank you as well, Deb. I think both of you guys have provided some great insights on how to align legal resources with IT projects. And if you'd like to learn more about this topic, or if you have other ICT needs, the three of us or any of our LB3 and TC2 colleagues would be happy to help. So please give us a call or drop us an email. You can also stay current by checking out our websites or follow us on LinkedIn.